Hi, everybody. I hope everyone had a minute. I don't know if it's nice there today, but it's pretty spectacular here. It's in the 70s, which is a pleasant relief from the heat that we've been having. So I hope that you guys had a chance to get out and enjoy a minute of fresh air, or at least attend to some urgent business that you had on the break. All right, so we're gonna keep going, and just please, if you have questions, please don't hesitate to jump in either in the chat box or out loud, unmute yourself and ask questions. So we're going to talk quickly about the two kinds of rapid rehousing subsidies that are available in Arlington. The first, which is the one that's the most commonly used, I think, in Arlington, is the bridge subsidy. And again, just to reiterate the point that Trina made before, don't assume that just because someone has a disability, they necessarily are only going to be able to make it on a bridge subsidy. People will surprise us. And, again, the progressive engagement model, starting with the least amount of assistance, we really want to try to see if people can make it on the graduated subsidy, if possible, so that we can reserve, as much assistance as possible and help as many people as possible. But the bridge subsidy is there for folks if they need it. And it really is intended to be just what it says, a bridge to a longer term subsidy. So in Arlington, you've got housing choice vouchers, or the Section 8 program. You've got permanent supportive housing. You've got that great local housing grant opportunity, which almost no other communities that we work in have, so that's awesome. And then you also have the newly available emergency housing vouchers through the COVID relief, and also I'm forgetting the name, but you guys have another award of long-term subsidies that you got also not too long ago. So there are multiple options for people to bridge. These bridges really are supposed to be reserved for the people who are eligible for another kind of subsidy, but also really have severe housing barriers and are just not going to make it in the graduated subsidy. And in this model, the tenant pays a minimum of 30% of their income towards rent. But if the plan is to bridge that person to a housing grant where they are ultimately going to have to pay 40% of their income towards what, we really want to get them started right away at paying 40% of that income, because otherwise that transition from 30 to 40% is very hard. And so if they can establish the habit and do the budgeting right out of the gate to get used to paying that 30%, it tends to go much better. The other kind of subsidy that's available for people is this graduated or declining subsidy. And again, here in this kind of rapid rehousing grant, people are going to pay a minimum of 30% of their income towards rent. But many people, particularly folks who've been in the program for longer, are going to end up paying more than that. So the way that the program is structured, it has both a minimum rent requirement and a cap on what the subsidy is going to pay. So for the first 3 months that somebody's enrolled, the subsidy can pay up to 100% of FMR. Months 4 to 6, the subsidy can pay 80% of FMR, and months 7 to 9, 60% of FMR, and then up to 18 months, 40% of FMR. So a lot of folks that are enrolled after the first 3 months are going to end up paying more than 30% of their income towards rent because of these caps. So when you guys get a referral from CCP for rapid rehousing, that referral is going to say what type of subsidy they're approved for, bridge or graduated, and it's going to say how long they're approved for assistance. And that request is made by the referring worker and then reviewed and approved by CCP. So people may just get 3 months, they might get 6 months, they might get 9 months, or they might get 18 months. I think 18 months is rare. Usually people are being approved for a shorter term. Again, the progressive assistance model to try and have people move off of the assistance and pay rent independently as quickly as possible. Now, we talked earlier about the importance of flexibility in rapid rehousing, right? So it's not one size fits all. So there is the opportunity, if somebody simply cannot make it in the structure that is designed, for you guys to go back to CCP and to Trina and to say, hey, this person needs either an extension on the length of assistance or the amount of assistance, or like we said earlier, they need to change the type of rapid rehousing that they're getting. They started out and graduated subsidy. We realized it's just not going to work for them and they need to move into bridge. But you've got to get approval in order to do any of those things. So those exceptions have to be approved by CCP and by Trina. And whenever possible, you should be bringing those conversations to the Rapid Rehousing Committee in order to engage with your partners around, what's everything, what are some ideas for trying things that we may not have tried, and make sure that everyone's on the same page, that the exception that you're asking for is what is necessary, that there's no other way to make it work. So, so quickly, just want to say, I'm not going to go through. HUD is great at taking simple concepts and making them incredibly complicated. So this is a ton of words on a slide. This is the HUD definition of family, that basically what it means is that people get to choose for themselves who is a part of their family, right? So if people apply for, say, I want help from rapid rehousing, and here's who's a part of my family, we don't ask them to prove that they're married. We don't ask them to prove that they're biologically related. We take at face value that people get to choose for themselves who is a part of their family, and we serve them as a family if they present together as a family. I know that the county is working on or probably the county in collaboration with the COC is working on a policy about this and about how we serve singles versus families. And so that will be coming soon. But basically the way that it works is that it doesn't matter like in your HUD COC grants, right? If you said on your grant, you're going to serve 100% families, HUD definitely understands that, who's a family today might be a single tomorrow and vice versa, right? People get pregnant, they have children, people's children turn 18 and they move out, right? So who you are actually serving at any given time is not going to match what you said on your project application, and that's okay. And it's okay both because the household composition changed because life happened, right? And it's also okay because the needs in the community changed, right? And actually the bigger need at the moment is for single adults and not for families. So you're going to serve more single adults than you had anticipated in your application. So what HUD says is that as long as you are predominantly serving the type of population that's in your project application, like that you don't have to get a contract amendment, right? So if you said in your project application, you're going to serve 10 singles and 10 families, and you're only serving 8 families and 12 singles, you don't need a contract amendment, right? If the needs in the community change radically and you said you're going to serve all families and now you're going to serve all singles, then I would go to your CPD rep and talk about a contract amendment. And what's significant or not significant, as is always the case, is not defined by HUD. So if you're on the line, you're not sure, just ask your field office whether or not they want you to do a contract amendment. They don't like doing contract amendments, probably more than you don't like doing contract amendments. So hopefully they're going to say no. Make sure you get that in writing from them or document it in an email. Okay, so so this is important. This is a policy, federal policy dating back to 2016. The reality of systemic racism in America means that people of color, Black people, Indigenous people, Latinx folks, right, are disproportionately arrested, convicted in our systemically racist system, right? And so any policy that restricts housing access based on criminal justice history is a discriminatory policy and is unlawful under this memo that is linked here on the slide. So basically what that means is that landlords that are accepting federal assistance, right, which your landlords are, cannot say, they cannot have a blanket policy that says, we don't accept everyone with this kind of criminal history. They've got to make an individual assessment based on the actual circumstances, right? How long ago was the conviction? What kind of conviction it was, and what's the reason why I can't serve this person safely in this housing. They also are not legally allowed to consider arrests. They can only consider convictions. So I know that this is probably very hard to get to happen in actual practice with your landlords, but that is the law, and there is, I think, far more so than there has been for the past 4 years, some juice in the Biden administration around enforcing this and making people more aware of this. So, all right, so we're going to do a quick Zoom poll to go over a little bit of what we've talked about. I know it's been a lot. So here we go. Can you guys see the poll? Can you guys see the poll?
Yes.
Okay.
Yes.
So the questions are, so you can just put your answers in there, and then we'll talk about it when you're done. We'll give you a couple of minutes to do this. The first one is, who is responsible for ensuring that each participant's file documents eligibility? The second one is, must members of a household be married or biological relatives to be considered members of the same family? And the third one is, can a landlord bar all people with a felony drug arrest? So get your answers into the poll. We'll give people a few minutes here, and then we'll talk about it. All right, give you 5 more seconds if you haven't gotten your answers in yet, and then I'm gonna share the results of the poll and talk about the answers. All right. So our first question, who is responsible for ensuring that each participant's file documents eligibility? So most people responded, it's the Rapid Rehousing Project that is admitting the client, that's who is responsible for ensuring that the eligibility documentation is in the participant's file. And that's exactly right. That's exactly right. So as the admitting Rapid Rehousing Project, you need to make sure that you have that documentation. Now, the referring worker is responsible for submitting a lot of that documentation to CAS, to CCP, and CCP is going to look for that documentation before they approve it, but ultimately read the responsibility to make sure not only that that documentation that was included in the referral is in the client's record, but also that the that any gap between when CCP made the referral and when you admitted, as we talked about, that you fill that gap and you make sure that you document that the person was still eligible up until the day that you admitted them. So that third choice is in fact correct. The second question, must members of a household be married or biological relatives to be considered members of the same family? Most people said no, and that is also correct. So again, the definition of family is very broad, and it's basically that people get to choose for themselves who's a member of their family, and it doesn't matter whether or not they're married or biologically related. So if that's not the definition of family that you're using in your program, and you are requiring people to only be family with somebody that they're biologically related to or married to, you want to stop doing that. The third question, can a landlord bar all people with a felony drug arrest? Most of you said no, and that is correct, right? The landlord cannot make, there's two reasons why that's correct. Number one, the landlord can't have any policy that's about arrests. They can only look at convictions. And number two, they can't have any blanket policies that say we automatically don't accept anybody with a felony, or we don't automatically accept anyone with a drug conviction, right? They've got to assess each case on an individual basis, looking at factors like how long ago, how serious was the offense, etc. All right.
Lauren, as you're also talking about that piece, I just want to remind folks, everyone should know this already by now, but that Virginia passed the income discrimination as a protected class in our fair housing law too. So landlords cannot discriminate an applicant based on any sort of subsidy or rent assistance that's coming in to help with the rental costs for a household.
Great, thanks, Trina. Okay, so I'm not going to go through all of this, but these are all, so now we've talked about all of the things that are sort of applicable up until the point that you enter someone into the program. I'm not going to talk about all of these things, but this is basically a list on this slide of all of the things that you need to make sure are in the person's record, in the participant's file at the point that you admit them. And the county also has on their website a checklist of all the documentation requirements, and so you might want to also it's linked later in the presentation. That's a tool that you can use. You can also refer to these slides to make sure that you've got everything in place. So, and then now we're going to talk quickly about what happens after somebody's admitted into the program, right? So obviously the first thing that we're going to do is we're going to help somebody find a unit. There's a ton of resources about best practices for doing this in the NAEH, National Alliance to End Homelessness, Rapid Rehousing Toolkit. And so I am not going to go through all of those best practices now. That toolkit is linked later in the guide. I do want to say just really quickly that the rapid rehousing model, remember, one of those three stools is housing search, right? And housing search means helping somebody to find housing, not just saying, let us know when you get an apartment and come back and we'll help you with the assistance, right? We'll help you with the financial assistance. So really in rapid rehousing, a core part of the model is being very proactive about recruiting landlords to participate and providing participants with help to find a unit that meets their needs and a landlord that is willing to sign a lease with them. And so by all means, if you've got somebody that's super industrious and independent and can do it on their own, let them do it on their own, right? But if a week later they haven't done it, like if they are not successful at very quickly identifying a unit, you want to try to step in and provide that assistance and offer that assistance to get them housed quickly. Because a lot of times people say, don't worry, I got this, I can do it on my own, actually really could benefit from assistance. And the expectation is that rapid rehousing programs do provide hands-on assistance with housing location. Okay, so lease requirements, we've divided this into two different categories, things that are required federally and then things that are local requirements. And so the federal requirements, the lease has to be a term of at least 1 year unless you've got a waiver. I'm not going to get into all the COVID waivers because I don't think you guys are using them. The renewable term for that lease has to be a minimum of 1 month. The lease has to specify that it is only terminable for cause, and you've got to document rent reasonableness, which I'm going to talk about in a minute. And then in addition to those things, Arlington requires all of the things in the housing first principles, right? So, basically your lease should be a standard lease, right? There shouldn't be anything wacky in a lease that's not in your lease that you have with your landlord, right? Shouldn't say things like this person has to participate in services in order to keep their housing, because that's not a standard lease. And then the only way to terminate housing is through the court eviction process, right? Landlords can't just say, hey, look, get out, right? They've got to, tenants have the right that rapid rehousing participants have the same rights as any other tenant. And Arlington requires that the rent for the unit is under FMR. So it has to be both rent reasonable, which we'll talk about what that means in a minute, and under the HUD fair market rent guidelines. Okay, so rent reasonableness. So when we say the rent is reasonable, what that means is basically you've done an assessment and you've found 3 comparable units, and the unit that you want to lease is not more expensive than those 3 comparable units, right? So if you've got a unit that the person wants to lease, you're going to use rapid rehousing money for, and that unit is $1,000 a month, the 3 comparable units that you found have to be $1,000 or less per month, right? So, and there's a rent reasonableness checklist and certification form here that you can use to document this. And you need to make sure that the comparable units are in fact comparable, right? So that means they're in the same neighborhood, right? They're the same unit. Like, don't use a 1-bedroom as a comparable for a 2-bedroom, right? They've got to be the same, approximately the same size, have to be exactly the same square footage, you know, and they've got, you know, basically the same amenities, right? You probably aren't renting many dormant units anyway. And then you've also got to make sure that when you determine whether or not the unit is below FMR, that you take into account the utility allowance. So if the tenant is responsible for paying any of their own utilities, you've got to look up, it's linked here on the slides, you know, what's called the utility allowance, which is basically an amount of money that you're going to apply. Like, so if the tenant has to pay their own electricity, you're going to take, I don't know what it is in Arlington, but like $30 a month for electricity. And when you decide whether or not that unit is under FMR, the rent with the applicable utility allowances added have to be under FMR. Okay, and we'll talk more about utility allowances when we look at rent calculations. You've also got to make sure that the units are inspected and meet housing quality standards, so HUD HQS. That form is linked on this slide. Also, if you have questions about what does and does not meet HUD HQS, what HUD calls the acceptability criteria, those are also linked on this slide. So you've got to do an HQS inspection and make sure that that HQS inspection is in the client's file prior to signing that lease. And you've got to do it if you're continuing to subsidize the unit, you've got to do it at least annually for as long as you're subsidizing the unit, which will not be more than you know, one annual recert. And you want to make sure that on the HQS form that who inspected it signed it, that the date that the inspection occur is filled out, because otherwise you don't know whether or not it was done annually or prior to lease signing, and that the unit that you inspected, it's clear that it's the same unit that's under lease, right? So a lot of times when we look at files, we'll see on the lease, it says apartment 2B, and on the HQS inspection, it says first floor. And I have no idea whether or not that's the same unit. So you want to make sure however the unit is identified on the lease, that's the same way it's identified on the HQS inspection form. Okay. Oh, and then finally, if the unit fails, if you say no on any of the things on the HQS inspection form, it doesn't meet this standard, then you've got to go back and reinspect. So you've got to show that the landlord made the correction and that you re-inspected the unit, and that also has to be documented in the file. All right, so income verification and rent calculation. So the county has created this handy dandy rent calculation form that really walks you guys through a lot of the stuff that I'm going to cover. So if you are not already using this form, please do use this form. You're required to use it, and it's also super helpful. So it's linked on this slide here. The one thing to keep in mind about using this form is that if you are doing a graduated or declining subsidy, the form doesn't automatically apply the caps, right? So if somebody's in their 4th month and the subsidy payment is capped at 80% of FMR, they're not necessarily going to be paying the 30% or 40% of their income, right? They're going to be paying, whatever the balance is after the cap is applied. So you do have to make sure when you're using this form that you take that extra step for the graduated subsidy. All right, so what counts as income? So basically Arlington in your rapid rehousing program, to keep the rules as consistent as possible, and there's already a lot of rules, having different rules for different programs gets super confusing for folks. So they use the same, you guys use the same standards around what counts as income as you use in all of your other HUD COC programs. And so basically, pretty much all income, except for the things that I'm going to talk about in a minute that are specifically excluded count, right? So you count their Social Security, you count their, any disability, any pension that they're getting, unemployment insurance, workers' comp insurance, any welfare money they get, alimony, child support, obviously any income that they earn, the gross income that they earn, right? You do it pre-tax, so their wages, their salary, overtime, tips, all of it. The only place where you use net income instead of gross income, which probably happens very rarely, is if somebody is self-employed and have their own business, then you're going to use the net income from that business, okay? Also, if somebody's getting regular gifts, like grandma sends $200 a month, you've got to count that $200 a month in their income. We'll talk in a minute about sporadic gifts. So these are all of the different kinds of income that are included. And then there's literally a list that's, 5 pages long in this chapter that's linked at the bottom of this slide in this HUD handbook about all kinds of obscure income and what's excluded and what's not excluded. We did not put all that on the slides. You'll be happy to know I'm not going to be going through all of that today. We're just going to talk about the things that are most common for our folks. And those things are, if you've got kids in the household who are working, you do not need to count their employment income. That is excluded. If grandma sends $100 once a year for someone's birthday, that's a sporadic gift. You do not need to include that in someone's income. And then most of these things rarely happen. So I'll just mention quickly the other one that we sometimes see is that somebody gets some kind of insurance payment or settlement for a lawsuit. That is not considered income. It's considered an asset. And in the COC, the Managing COC Grants training that's on the county's website that Howard and I did a couple of years ago, the details of how you impute income from assets is in those slides. We're not going to have time to go through it today. What I would say to you is that if you've got a kind of income that you don't typically see, and you look at whether you look at that type of income against these slides and it's not mentioned on these slides, either as included or as excluded, then go to the handbook that's linked here and see how you're supposed to treat that income. And if you have any questions, feel free to reach out. I think, first reach out to Trina, and we're also always happy to weigh in as needed. All right. So these are the things that you have to deduct. So first you figure out, okay, what is the income that someone has? And you enter all that income into the handy dandy spreadsheet that the county has provided. And then you have to figure out, okay, are there any deductions that the household is eligible for? And then you also enter those deductions into that spreadsheet. And again, I'm only going to cover the ones that are most common. And those are really the first 3 that are on this slide. So the first one is for every dependent in the household gets $480 deducted from their income for each dependent. The second one is the disability or elderly deduction. So if there is any member of the family that is either disabled or elderly, that deduction comes out of the income, but it's only once. So even if you have two disabled people, they only get the elderly or disabled household deduction one time. All right. So another important thing is that if somebody is saying that they have no income, then you need to document that they have no income. And so it's hard to document something that doesn't exist. And so typically the way that we do that is by having participants attest on some sort of affidavit that they are attesting to the fact that they have no income, and there is a sample of such an attestment linked here. You want to make sure that you've got that in the file anytime you're working with a participant that is reporting zero income. You've also got to make sure, so for rapid rehousing, we do income review, you know, at outset of entry into the program and at least every 90 days. Now, if someone's income goes down, right, and the way that we recalculated their rent isn't going to work anymore because they lost their job, you can recalculate the rent sooner than 90 days, but you're not required. You're only required to, you are required regardless of whether or not the income changes to do it every 90 days and to have a discussion with the person about, it's part of the whole planning process around what's the long-term plan here and where are we towards, getting you enough income. How can we help you get more income so ultimately you're going to be able to succeed in this program? And you've got to make sure that you've got all of the income documented, right? So if on that spreadsheet, it says this household has $1,000 of income, some of it, maybe the mom has a job, the dad is disabled and gets disability income, whoever has income in the household, you have to get all of the documentation for all of that income, and the documentation should add up to whatever the total is you put on the spreadsheet. And you also want, if you're taking deductions, to make sure that those are documented, right? So if you're saying that somebody's getting a disability deduction, you want to make sure you have a disability verification in the file is probably the most common one. Okay, I'm not going to go through this example. We're running short on time and you guys can read it after, but this basically shows you one approach because you don't always know. I mean, people have unstable work situations, right? So their income changes from month to month. So basically what you want to do is you want to use the information that you have to anticipate to the best of your ability what the future income is going to be. And this is just one example of how you might do that. And if you were wrong, you can always recalculate, right? All right. So utility allowance, I said that I was going to get to this. So this is important and I think confusing for a lot of people and maybe not necessarily something that everyone is always doing, but it is a requirement, right? So if the utilities are not included in the program participant's rent, right? So the participant is required to pay some portion of their own utilities. You've got to consult that. You've got to figure out, okay, what does the landlord pay and what does the tenant pay, right? That has to be documented on the lease. Right, and you've got to go to that utility allowance schedule and say, okay, the tenant pays for electricity and hot water. Electricity's 30, hot water's 10, so that's $40 that they're entitled to in a utility allowance. Okay, and if when you calculate their rent share is $90, and let's say the utility allowance comes up to $100, the program basically owes them $10, right? So you've got to pay the utility company that difference between the utility allowance. If the tenant's share is less than the total utility allowance that they are entitled to, you've got to pay that difference to the utility company. Okay, so you want to cut a check to the utility company to pay that difference. All right. So I'm not going to go through these calculating rent and shared housing scenarios because I think you guys aren't doing that much shared housing, although we definitely encourage you to be doing shared housing. And Andrea and I did a whole training just on this a few months back, and that training is on the website. So if you're doing shared housing or you want to be doing shared housing or you're not doing shared housing and it's a great strategy to get people to afford housing in an expensive market, please check out that webinar.
Hey, Lauren, quick question
Yeah.
coming in via chat. On the utility allowance, does that fluctuate on a monthly basis?
No, the utility allowance, so the county establishes a utility allowance on an annual basis. So you want to make sure annually when the county updates that utility allowance schedule, that you get the new schedule and that you use the current schedule, but it's not going to change on a month-to-month basis, right? Because what the person's responsible for paying is in their lease, and the leases are almost always 12 months, right? So that's going to only change if they sign a new lease. And then what is in the utility allowance schedule, the county's only going to change that once a year. All right. So we're going to do another Zoom poll. All right. So polling. All right, you guys should be able to see the poll. Can you see the poll? Technology gods are smiling upon us today.
We're at 99%.
All right, so the first question is, if a person works about 1 day per week doing day labor, does that count as income? All right, and the second question is, does the utility allowance cover 100% of utilities? And the third question is, if there are 2 disabled people in the household, do they each get a disability deduction? So we're going to give you guys, we're running short on time, so I'm just going to give you a couple of minutes and then we're going to go through the answers. So get your answers in there quick. All right, 5 more seconds to get your answers in. No pressure. No grades. All right, I'm going to end the poll and share the results. All right, so on our first question, if a person works about 1 day per week doing day labor, does that count as income? And most of you said yes. So that's right, you are correct. Regardless of whether that day labor is on the books or off the books, right? There's no exclusion for off the books labor. So if someone is doing off the books labor, that is still countable income, and you should document it in whatever way you can. If you are not able to get any kind of third-party documentation, then a self-certification from the person is, what you can do, but you need to document whatever efforts you made to get that third-party documentation. And it would not be considered sporadic because it's 1 day every week, right? So sporadic would be like an election worker. That's one that we see often. Somebody volunteers or works at the polls once a year and they get paid once for that. That would be sporadic. But somebody that's doing day labor every single week, that would be considered countable income. The second question is, does the utility allowance cover 100% of utilities? And most of you guys said not usually, which is correct, right? The utility allowance schedule, if you've not already looked at it, it's very low, right? The amount that you are going to credit somebody for utilities is almost always going to be less than what they are actually paying for utilities. HUD says that the utility allowance is meant to reflect an energy conserving household. I consider myself to be very energy conserving, and I honestly do not know how one conserves enough energy to be able to have their utilities come in under those allowances. So technically it's possible, I guess, that it covers the entire thing, but in practice, I've never actually seen it. So you guys are right. It does not cover 100% of utilities. And then the third question, if there are 2 disabled people in the household, do they each get a disability deduction? And the correct answer here is no. So if you've got multiple dependents in the household, they each get a dependent deduction, but the disability deduction is applied just one time for the entire household, right? So they're only going to get that $400 once for the year. Okay, so let's keep going here. This is not going away. Okay, so again, I'm not going to go through all of this, but this is the documents that you need to make sure are in the client's file prior to or at each lease signing. I did just want to say really quickly, because I think this can be a little confusing here at the end, a written agreement with the landlord and a written agreement with the tenant. So that's different than the lease, right? So the state actually requires that you have the rapid rehousing program have a written agreement with both the tenant and the landlord. And that agreement would, for the tenant, right, you want to say how much you're going to pay, how much they're going to pay, what the expectations of them are in the program. The specifics about what the state wants to see in that agreement with the landlord are in the state requirements that are linked on the slides. I'm not going to go through them all now, but if you don't already have such an agreement in place with your landlords, you want to make sure you consult, and you've got state funding, you want to make sure you consult those state guidelines and get that in place. I actually think it's a good idea to do for all programs, right? Having that written agreement with the landlord, between the landlord and the program is, I think, always going to be a best practice. So, okay, so these are the things that you want to make sure that you do, not just initially, but also at each 90-day recertification. And I'm just going to go through them really quick, right? So you've got to update the income and the asset calculations, right? And make sure that you've got the backup documentation for each of those things. You're going to do that rent calculation spreadsheet that the county has provided. If there's a change in the subsidy amount, you're going to update that written agreement with the landlord and update that written agreement with the tenant, so everyone is clear on who is responsible for paying exactly what by when. You're going to update your housing barriers assessment, and remember, it's not just the filling out the form. You're going to take all the information that you've learned about this person through all the great work that you've done with them, and use that to to help assess, what the barriers are for the person to stay stable and what the goals should be in the housing plan. And you're going to evaluate what's worked in the housing plan, celebrate those successes, figure out when things, goals weren't met as you had anticipated, and make adjustments, not just recycle old goals in the housing plan. And you're going to do each of those things every 90 days. Okay, just a couple more quick things before we end. We're nearing the end here. It is possible, right, to use rapid rehousing dollars in concert with other kinds of dollars to provide just services when people need it. So for example, if you've got somebody that doesn't need financial assistance from rapid rehousing because they won the lottery and they are at the top of the Section 8 wait list and they're going to actually get a housing choice voucher, woohoo, congratulations for them, but they need some services in order to stay stable, get connected to services in their new community to make that placement really stick. You can pair rapid rehousing services dollars with an ongoing subsidy. And if you need help how to figure out how to do that, Trina is available to help you. What you cannot do is double dip, right? So you can't provide rental assistance, both from the Section 8 program or the housing grant program or any other kind of subsidy program, and also provide rapid rehousing rental assistance. You can never provide the same assistance through two different kinds of funding, really in any kind of public, publicly funded benefit. Trina made an excellent point. There's a particular program that you guys have in Virginia. It's called the Virginia Rent Relief Program, and you cannot use that program in concert with rapid rehousing. And if you've got questions about that, there's some links here that that Trina provided to some FAQs about that program. So again, that's a double dipping thing. Okay. So when you get to the point where someone hopefully has done fabulously and has a great job in an apartment they love and their kids are finishing school, and you get ready to end their participation in the rapid rehousing program, there are some things you want to do. Sometimes, unfortunately, so we're going to talk about termination for the rapid rehousing program now. Sometimes, unfortunately, we terminate people when all of the great things that we had hoped were going to happen didn't happen, right? And there are reasons why, we have to terminate folks from the program. Like, for example, they are not providing the required income documentation, or they've just gone completely missing, and we cannot find them or engage them in services. So when that happens, there's some steps that you want to take. If it's not a positive, like congratulations, you're ready to move on, we're so happy for you kind of termination, right? You want to make sure that you take these steps before terminating them. The goal in rapid rehousing, obviously, is to have everyone be stable, but we're not always going to be able to get there. And so if you think you have to terminate someone before they've reached stability, please be sure that first you've tried everything you possibly can to engage them and have a conversation with them and refer back to the program agreement, and do like some course correction and find out what you could be doing differently to helping them better. And then if that doesn't work, you want to elevate it for discussion at the bi-weekly rapid rehousing, at the bi-monthly rapid rehousing meetings, if possible. Sometimes the timing on that is not going to work out, and or refer them for case conferencing to CAS to make sure that as a community, collectively, we have done everything possible to help and support this person before we terminate them in a way that is not going to necessarily mean they're going to be stable moving on. And then you want to make sure you document all of those things that you've done. And then regardless of whether or not it's a successful termination or a termination, an involuntary termination, we want to make sure that every person gets a written notice of termination saying that your assistance is going to end on this date. The reason why the assistance is going to end on that date, and it might be because they've are paying their own rent now. Congratulations, excellent. You want to make sure also that you've documented at the front end that you've got, in case you do have to do an involuntary termination, what the expectations are for the program, that documented that that person received those expectations when they came into the program. And then you want to restate those expectations, whatever they didn't meet in that termination letter. And this is super important. You've got to give them the right to appeal. So every termination notice, regardless of whether or not it was a voluntary or involuntary termination, should say you have the right to repeal, and these are the steps that you take to that appeal. And we didn't talk about this earlier, but it's listed on the slide of the things that need to be provided prior or at intake. You've got to make sure at termination, you provide again the required Violence Against Women Act forms, or VAWAN forms, which is the notice of occupancy right and the incident certification form. And those are linked in the earlier slides. Okay, I'm gonna wrap us up because we are at the end of our time. So you also need to make sure everybody always has a right to grieve. Every agency is required to have a grievance policy. You want to make sure people get that grievance policy at project entry. If people have gone through your agency's grievance policy and they remain dissatisfied, then they can go to the COC and file an appeal or grievance with the COC, and they would do that by contacting Trina. And then just a couple of quick next steps. So the county has asked Housing Innovations to do some monitoring of visits, monitoring of rapid rehousing programs. We'll do those visits remotely, and it really is intended to help you guys. It's not a gotcha situation. It really is intended to help you guys to say, you know, here are the requirements, right? Here's what we're doing. How aligned or not aligned are we with the requirements? And for you guys to identify places where your practice needs to be better aligned with the requirements. So when we're going to do that is going to be sometime after the COC competition, you know, probably depending upon the COC competition, like November, December. But we wanted to do this training first, right, to make sure you guys had an overview of what all the requirements were before we started doing that monitoring. We won't be monitoring every program. We're going to be monitoring, I think, probably a subset of programs, although that's kind of to be determined. So we are out of time for questions, but I will stay on if people have questions. So if you've got questions that weren't answered today, please stay on and I will answer those questions to the best of my ability. If there are things that we did not cover in today's training that you want us to cover in future trainings, let Trina know, put it in the chat box or stay on for a couple minutes and tell us what those things are. And then here are all the resources. These are just the resource slides that we talked about, you know, during the presentation today. This is the link to all the past webinars that are up on the the county site that I was mentioning. So hopefully you can find them easily there. There's some upcoming webinars that the county is planning to do, one on crisis intervention and one on critical time intervention, and the details and dates for those will be coming soon. And then this is just, you know, all of the links to all the different federal requirements, which is quite overwhelming. The links to the different state and local requirements. This is the monitoring guide. It's, if not exactly, very similar to the guide that we'll use when we monitor. So if you want to know what we're going to be looking for when we come out and monitor, it's an open book test. You can see the guide right here. And that's it. Sorry for the end speed talking. So thank you guys for joining us today. I'm sorry that we went 3 minutes over. I appreciate your time. And more importantly, I appreciate all of the work that you do with such compassion and kindness every day for the clients that you serve. So I hope that you enjoy the rest of your day. I'm going to stop the recording, but welcome people to stay on if you have questions.
Thanks, Lauren. Oh, go ahead. Go ahead, Ayana. Jump in.
I'm sorry. I just had a few little just clarifying questions.